Your Honor, counsel, officer, good morning, ladies and gentlemen of the jury. Ladies and gentlemen, Bradley Caraway is not guilty. And some of the most important facts in this case you never heard in that opening. Right at the beginning, I'm going to acknowledge to you the tragedy of this case and acknowledging the grief everyone feels, including Ms. Moorman's family. But there's truth to be had in this case. There's a truth as to who was driving. There are facts, there is science, there is DNA, and they all point one way. And the truth is, Bradley Caraway was not driving the vehicle when it crashed. Now, let's begin. Let's go back to the night of August 5th going into August 6th. Shanae Moorman goes out with friends. As you've heard, she goes to 4th Street, then goes with friends to the Tin Roof. From the Tin Roof, she, for whatever reason, decides to split up from her friends. And she goes to Gerstl's, Frankfurt Avenue, St. Matthews. She's at Gerstl's. She and Mr. Caraway meet each other, drink together, all right? Some may assume that because Mr. Caraway's older, he was the one who was, I guess, initiated or was aggressive in the interaction. But in fact, ladies and gentlemen, we'll show you that that is not the case. Both were, Mr. Caraway was intoxicated, Ms. Moorman was intoxicated, the medical examiner did a toxicology on her, they're both drunk, and they leave together around 2 a.m. Now, ladies and gentlemen, when they leave, again, you don't have to take my word for it. There is video at Gerstl's, and you're going to see it. We're going to play it, but you'll see how they leave and who seems to be in charge and who's leading who out of the bar. We'll play it in trial. Let's play it one more time. But she takes him by the hand, and she is leading him out of that bar. And she's going out first. He is following, ladies and gentlemen. He is following her out of the bar. They get into the Honda, all right? They're on 64 East. There's light traffic. Yes, they're speeding, but I think the speed limit is something like 70. The car's traveling, leaves the roadway. When they try to take the ramp, the Honda tries to take the ramp at the I-265 exit, does roll over, land on the roof. She's ejected, and the car lands on top of her. Now, the medical examiner will say that she died of what's called traumatic asphyxia. That is, she couldn't breathe. According to the medical examiner, her death would have been perhaps within 3 seconds, possibly as long as a couple of minutes, but certainly could have been within 3 seconds. And he'll also tell you that there was a head injury. Not fatal, but there was a head injury that could have rendered her unconscious immediately. All right. Bradley Caraway survives. They talk about him leaving the scene or didn't calling. His phone is left at the scene. He's shocked. He's intoxicated. All right. He's also likely concussed. All right. He's wandering around, and then they see him sometime later. What's he doing? He's walking around, sticking out like a sore thumb. He's on the highway. When police approach, sound the siren, he approaches the car. He's in shock, as I said, possibly concussed, no shirt, no shoes. All right? He's not diving into the woods, hiding anything. He walks towards the police car. They figure out, at this point, they ask his name, gives his name. They then know at that point, they know he's the owner of the Honda. They take him into custody to take him to the hospital to try to show at that time that he's the driver. Now, ladies and gentlemen, initially, they say Miss Moorman's the driver. Then, when they find Mr. Caraway, I mean, before there's anything, I mean, before there's an investigation, before there's DNA, before there's a crime lab, on body cam, a detective says, he's our driver. I mean, as soon as they heard that a guy was there, he's our driver. I'm sure he was the driver. And they haven't done any investigation, one little bit of investigation at that point. None. Now, ladies and gentlemen, the accident is August 6th. On August 10th, 4 days later, no evidence has been analyzed. Nothing's been analyzed. They say, hey, and they charge him with murder. That's on August 10th, 4 days. Nothing's been tested. Nothing has been tested at all. And now the charge is murder. So they've gone from, hey, we're sure it's the driver, to murder in literally 96 hours. Now, I mentioned there's scientific proof. There's going to be evidence in this case, data, analysis. And I'm going to set it out to you. Police go and they have the car swabbed, okay, various parts of the car, where they think there's blood, okay? And then they send it to the Kentucky State Police Crime Laboratory. That lab tests for the entire state, for police here, for police across the Commonwealth, for prosecutor's office, for Commonwealth attorneys. They do the testing. And Kentucky's had the ability to do DNA testing for years, okay? So one of the places that they found blood was the passenger side airbags, okay? The passenger side airbags. That's blood on the airbags, passenger side. All right? And the reason they wanted to test that blood is because they wanted to see who's sitting on the passenger side. All right? The airbag only deploys when there's the accident. There hadn't been an accident before, so this is from the accident. And they took it because they say, whose blood's on the passenger side, that'll show who's on the passenger side. So, the Kentucky State Police Crime Lab tests the airbags. They test the blood on the front of the airbags, and they test the blood on the back of the airbags. They have Bradley Caraway's sample so they can match. And you know whose blood was on the front of the passenger side airbag? Bradley Caraway. You know whose blood was on the back of the passenger side airbag? Bradley Caraway. The DNA is Brad Caraway's. And in addition, they found something even more, just as significant. The crime lab will tell you that often when they test DNA, they got blood, they will find that there's what's called a major component. That is, who contributed most of the DNA to the blood or whatever item it is. But sometimes they find a mixture, okay? It belongs to X, but there's another person who contributed. We don't have enough to tell who it was. We can't say who it was, but there's at least 2 contributors to the DNA. It's pretty simple. They find blood, okay? And is there a mixture? In this case, the blood on the airbags, there is no mixture. It's all Bradley Caraway's. Nothing belonging to Miss Moorman. Nothing. It's all Caraway's blood, and her blood is not on the passenger side. And that's the result of the state police test, in this case, that the Commonwealth asked for. They collected the DNA, they collected the blood, they sent it to the crime lab. They, ladies and gentlemen, asked the crime lab to examine it, and that is the police result from that exam. They also did something else. They hired a person named Scott Burrows. I don't know what Scott Burrows is going to say today, but he has assisted the Commonwealth over the years, police, in accidents, examining cars. That's what he's done. He's done it for decades. And he's worked with authorities, worked with police on these accidents. And they take the car, they want Burrows to examine the car. And yeah, he examined the car and he says, I don't think there's any, mechanical defects. But he also says this. He examines the seat belts. Okay? That's their expert, examining the seat belts. He says, seat belts in back, not locked. He said, driver's seat belt front, not locked. The only seat belt that he said appeared to be locked activated was the passenger side seat belt. Now recall that Bradley Caraway survives the crash. They say he's seat belted. In fact, he is seat belted. She's ejected. She's not seat belted. Their expert says that the driver's seat belt didn't lock. The only one that did lock was the passenger side, and Caraway was the only person in the car restrained. So the passenger side seatbelt is locked, and Bradley Caraway's blood is on the front of the passenger airbags, on the back of the airbags, and the seatbelt is locked where he's sitting. Let's keep going. This evidence here of Mr. Burrows, and I'm giving you their proof, Mr. Burrows, their proof, the DNA results, their proof. They also come against a background, a context you'll hear of basically what we'll prove or what the evidence will show is a sea of reasonable doubt. What do you mean by that, Mr. Egger? Well, ladies and gentlemen, in every case, the experts will tell you, police will tell you, common sense will tell you, one of the main things you want to do is preserve the crime scene, the accident scene. You want to reconstruct something, you have to kind of reconstruct from as is, so to speak. But in this particular case, what happened was, for whatever reason, the integrity of the scene was destroyed. Pictures were taken, but they went to the scene of the accident and they were throwing things in the back of the Honda. It became a receptacle for evidence. The Honda did. They found the bumper of the car, just pitched it into the Honda. Miss Moorman's wig is found in the Honda. That might say, man, that might tell us where she is. Fortunately, it wasn't found in the Honda. It was found on the grass, and they just threw it in. We believe even some stuff that had been in the car was thrown out of the car. So the crime scene is a nightmare. It's not preserved as you would want it. And evidence thrown on the ground, I think they found even the bumper. They threw the bumper that they found in the car. Now, photos were taken, but and they're dealing with fast-moving situations. But this scene is a nightmare. Let's keep going. That morning, or that early morning hours of the 6th, police go to, obviously, the scene. and they do what's called a mapping station. And that's just a fancy word. Again, we use our common sense. They map out the yaw marks and the tire marks to try to get the route of the vehicle. All right? So they go out and they do a mapping station and they mark out the route of what they say is the car, the Honda. That's that morning, or in the early morning hours of the 6th. Well, that's the traffic unit. Somebody else in the traffic unit looks at it and says, wait a second, I think we mapped the wrong vehicle. This is a murder case. They're going to tell you they mapped the wrong vehicle. So they go back later on the 6th. They come back and map other marks. Now they say, well, we've got the right vehicle. We see skid marks here. And actually, we see marks and they overlap. And we'll show you more, but they overlap. So the two different mapping stations intersect. What's the significance of that? There was another vehicle going 100 miles an hour right around this same time, going a high rate of speed. And we'll never know if this vehicle was connected to the crash, or we don't know. We have no idea because they never pursued it. We don't know if this vehicle had been following the Honda, chasing Honda, we don't know. But there's another vehicle going at least 100, flying right at the same time, and there's marks there of that vehicle, and they even mapped them out because they thought it was this vehicle. Ladies and gentlemen, situation here is with Bradley's blood being on the passenger side, and with their own expert saying the passenger was restrained and Bradley surviving the crash. What will the Commonwealth present to you? Well, their main witness is Dr. William Smock. All right? Now, Dr. Smock will present you his credentials. All right? He'll talk about the books he's published and all the investigations he's done and the chapters in books that he's edited. He will go on and on about his credentials. He'll even tell you that he's a member, I don't know why this is, of the Aspen, Colorado Ski Patrol. But the evidence will show that Dr. Smock is not an unbiased witness. He is not an independent witness. He is not someone, ladies and gentlemen, who's coming in here and doing an independent job. We'll show you that Dr. Smock is on contract for the police department and has been for years. We'll show you that even on his resume now, he describes himself as a detective. We'll show you that he is biased. Why does he do this? He makes a lucrative living as a consultant. The evidence will show he can't treat people, at least in this city, because he doesn't have any privileges in any hospitals. But they'll show, and here he is at the scene wearing police gear that morning. That's Dr. Smock right there in police garb. And we'll go beyond that. We'll tell you that Dr. Smock tried to take control of this case from the traffic unit. And he went to the scene without anyone else being there that morning in his police unit, and he tried to wrest control of this case. Now, Dr. Smock has been the Commonwealth's or prosecution's go-to guy for years. He'll say, of course, Bradley's the driver. What's it based on? What's it based on? All right. He says, the front windshield, okay, sort of collapsed, kind of caved in. It's fractured, okay? I don't know if you've got a picture of that, but it's fractured. Okay. And police take swabs from the front windshield, okay? Now, they took 2 swabs, and for whatever reason, they only tested one of them, okay? I don't know why, but that's what they did. And so Dr. Smock will say, well, see, the blood here that's on the front windshield, that came back to Bradley Caraway. That's correct. He says it's on the driver's side. Technically correct, but not accurate. You'll see when we show you pictures that came from the front windshield, but to the right of the steering. The question is, how did the blood get there? It's a rollover crash. My client's bled from the hands. And we submit that it came from his flailing around with the hands, and it hit this glass that was fracturing in. Dr. Smock will tell you this is how it got there. He will tell you that Bradley Caraway's forehead hit the windshield. He will then tell you that it caused an abrasion. He will then tell you that he got glass out of the abrasion, and then he'll tell you that the transfer was from the forehead. He transferred his DNA when he hit the windshield. Now, it all sounds so scientific. It all sounds so good. One problem. It never happened. There was no abrasion on his forehead. These are their pictures. He never got glass out of the abrasion. They videoed it. He examined my client head to toe on the morning of the 6th. There was no abrasion. There was no cut. There was no glass out of there. This is Dr. Smock. None of it's accurate. That's police picture. There's no glass out of there. There's pieces of safety glass without blood on his hair. None. But ladies and gentlemen, unfortunately, there is someone who has a significant wound to the forehead. A wound consistent with impacting the windshield. A wound that's obvious. And photos were taken by the medical examiner. And that's Miss Moorman. Dr. Smock will also tell you about she would have lived for 4.5 minutes. Medical examiner does the autopsies here. We have a Kentucky State Medical Examiner's Office. They do the autopsies throughout the Commonwealth of Kentucky. So a medical examiner did the autopsy, and that medical examiner said, as I said, she could have died within 3 seconds, could have been maybe 2-3 minutes at most, and she may have been unconscious immediately. Dr. Smock is saying this 4.5 minutes basically to make people mad. But there's something you should know here when you listen to him about that. In his resume, he says, he lists at some point associate of pathology. I'm naive. I think, well, if you're an associate of pathology, it means you're a pathologist. He's not a pathologist. Kentucky's medical examiner will tell you he wouldn't let Smock do the autopsy. No autopsy in this state. Would he let him do? He can't give a cause of death for the medical examiner's office because he's not a pathologist. So they're bringing on someone on cause of death and how long they'd supposedly be there and everything else, and the guy didn't do the autopsy, wouldn't have been allowed to do the autopsy, wasn't allowed to do the autopsy, and isn't, as I said, a pathologist. All right, what else now are we going to hear? We're going to hear about this EDR, this event data system, and so forth. There's a couple of things we want to tell you. We've got more than a couple, but in this opening, I'll mention just a couple. First, this event data retrieval, it's got its own disclaimer. The people who manufacture, put it out, have a disclaimer. And what this disclaimer says is right here. Event data should be considered in conjunction with other available physical evidence from the vehicle and scene. It's not the be-all and end-all. It's a tool to be considered with other evidence. Other evidence in this case being the blood on the passenger side belonging to Miss Moorman, being Scott Burroughs, being other evidence as well. Second of all, this data retrieval is contradicted by their own man, Mr. Burroughs. And there's additional thing about the event data retrieval. I'm telling you right now, we're going to put on some evidence in this case, okay? We are going to put on some evidence. We don't have to, we are. And we're going to specifically talk about something they didn't mention on that event data retrieval. What else do they have? Well, you know, Bradley Caraway is wandering around. They ask him, he is confused, gives various answers, you know, unsure what happened and really doesn't remember and is likely concussed. And they'll try to use those statements, but one thing he doesn't do, he doesn't say he's driving. It's right in the University Hospital records. Denies driving. Now, ladies and gentlemen, try to summarize things for you. Bottom line of this case is this. Their proof, their symptoms, their facts, their experts, all puts them on the passenger side. By the time that DNA report came out from the lab about the passenger airbags, he'd been charged with murder for more than a year. I'm going to close in a few moments, but a couple of things I want to mention. Again, acknowledge the tragedy of it. I mean, these are two people who met at a bar, left together, both, you know, had been drinking. Here we are. Second, people sometimes think that there's secrets or whatever. Case happened in 2016. The delays here are nobody's fault. They're not their fault. Certainly not the judge's fault, not defense counsel's fault. Testing took a long time. Then there was COVID, and we didn't have much choice. That we were ordered to shut down in terms of trials. Then finally, when things were resuming, the then attorney became very sick, intensive care, had to retire from the law, and so Mr. McGee and I were hired. But there's no secrets to that. And I guess the final thing I want to mention is this, and I'm going to close with this. One of our jobs here is to seek the truth. It's easy to be swayed by emotion. We're trying to find the truth here. And in this case, there is a truth. There is science. There is fact. There is proof. It all leads one way. Bradley Caraway is innocent. Thank you.